Can your spouse sell your home without your consent? Hi, I'm Simon de Pinar and I'm an attorney. It may seem impossible and it is rare, but it does happen. Let me explain. When couples are married in community or property, both spouses are equally responsible for the management of their joint estate. This means that certain transactions such as selling a jointly owned property require consent from the other spouse. Both parties need to co-sign legal documents. So how can one spouse sell the jointly owned immovable property without the other knowing? Well, when two people inhabit the marital home together, it would be impossible for one spouse to put the house on the market without the other knowing. But when a marriage starts to break down, warring couples sometimes separate before divorcing. One partner stays in the marital home, the other moves away. A deceptive spouse might try to sell the jointly owned property without the consent of the other. And what then is the purchaser's position? Now, if the deceit is discovered in time, the sale may be invalidated and then they have lost out. Whose responsibility is it to check that the requisite consent has been granted for the sale? The law is clear. The Matrimonial Property Act states, such a spouse shall not without the written consent of the other A. alienate, mortgage, burden with the servitude, or confer any other real right in any immovable property forming part of the joint estate, or B. enter into any contract for the alienation, mortgaging, burdening with the servitude, or conferring of any other real right in immovable property forming part of the joint estate. Whew. That's the law, but legislation is subject to interpretation, which is why case law is helpful. I'll come on to that in a bit. It is the purchaser's duty to find out whether the consent of the non-contracting party has been obtained. It's not enough for the purchaser to rely on the contracting party's claims to be unmarried or married out of community of property. The courts place the responsibility to conduct an adequate inquiry into the facts on the purchaser, not the conveyancer. Now, I want to say a word in defense of conveyancers. They are conscientious and they do check, but a seller may depose to a fraudulent affidavit confirming they have the required consent whether or not it's true. If a person alleges to be unmarried, does not provide a marriage certificate, and the Department of Home Affairs records reflect the person to be unmarried, the conveyancer can reasonably assume the seller is telling the truth. Now, there are two cases that contribute to our understanding of whose responsibility it is to ensure consent before sale of a property. Bukewa versus Nchana and others 2020 and Fisser versus Hull and others 2009. Both hinge on the extent to which the purchaser could reasonably have known that the seller was married in community or property, and the judge in each case came to a different conclusion based on the evidence. In the Bukewa case, the purchaser was deemed to have done an adequate investigation, as the deed of transfer cited the transferor as unmarried and the power of attorney further confirmed him to be unmarried. However, in the Fisser case, the purchaser was a blood relative of the seller and so could reasonably have known the seller's marital status. The court remained unconvinced that the purchaser had done an adequate investigation. If a sale goes ahead without the consent of a spouse, the Matrimonial Property Act allows for reparations for both the non-consenting spouse and the purchaser. Should the purchaser prove that they did not know and could not have known that the seller required the consent of the non-contracting party, the agreement is deemed to be valid and enforceable. Should the purchaser fail in proving the above, the agreement is void and the registration of the property into their name is undone. If undone, the purchaser is unlikely to be successful with the damages claim against the seller. For the non-consenting spouse, the joint estate must have suffered a loss for their claim for fraudulent concealment to be considered. Should the non-consenting spouse be able to prove that the spouse alienated the immovable property without the required consent, they can potentially get an adjustment in their favor upon the dissolution of the joint estate. These two actions are in effect duplication, as the spouse has to present the same evidence as the purchaser against the contracting party. To avoid this, the two parties can join their actions. However, if the non-consenting party prefers not to join the purchaser in the action, the claim against their spouse is not affected. Conveyances, by definition, are thorough, and any transfers my firm, ST Law, handles, we are observant and careful. We will always protect your interests. But it's worth remembering that as a purchaser, you have a duty to ensure the sale is legitimate, especially if the seller is a relative. For any queries or property transfer, give me a call on the number in the signature below.